Hello and welcome to this presentation about the Privacy Act. The context of this is that this is intended for VCE computing students in Units 3 and 4 software development. I do have a separate presentation for students doing Units 1 and 2 computing, and I don't have any presentation for students doing data analysis because it's not something that I teach. So this is specific to Unit 3 and 4 students who are often in Year 12. Students can explain the general purpose of the Privacy Act and the Australian privacy principles. Not all of them, but there are I think 6 or 7 you have to know about. So the first thing you need to know is that the Australian Privacy Act is in fact an act of the Australian Parliament, and it was either passed or enacted in 1988. I'm not sure which. In general, it applies to the Australian federal government, its agencies and some state and territory agencies. And it applies to many, I've said some here, but private sector organisations. I don't know if it's numerically most of them, but it's a lot of the ones that you'd be dealing with. So in the government sector, we're looking at federal government and the federal government agencies, Centrelink, Department of Defence and so forth. Entities performing public functions. So if you're acting on behalf of the federal government, let's say, I would say hospitals, for instance, which I don't think you're actually a federal government employee, but they are performing the function for the federal government, and some state and territory organisations, but I wouldn't get too fussed about that. In the private sector, organisations with an annual turnover, so turnover is money coming in and money going out, of more than $3 million a year. That's an awful lot of organisations. Some small businesses, even if your turnover is less than that, if you're handling sensitive personal information, let's say you're a data broker for instance, private health providers, and some people who are contracted to do government work, so there's they're to do service providers to the government. Who's exempt? Well, not everybody has to play by these rules. As I said before, small businesses with a small turnover, less than 3 million. Some charitable organisations don't have to comply with it. Political parties, it's amazing what they don't have to comply with. And media organisations in certain journalistic contexts. So not in all contexts, but to do with their sources, I suspect. There are 13 APPs in total, but we're really only interested in a few. We're interested in APP1, which is about open and transparent management of personal information. APP2 I'm not going to be covering in this presentation, but that was covered in the Year 11 presentation, so there shouldn't be questions about it on the exam, but I'm putting it in here because hopefully it rings a bell for you. APP3, which is about collection of solicited personal information. That means when you're asking for information. APP6, which is about the use and disclosure of personal information. So when can they disclose your information to other people? APP8, which is cross-border disclosure. When can they share it outside of Australia? APP9, which is about government related identifiers and when they can use those. And the final one, so what have we got? About 1, 2, 3, 4, 5, I think 6 in total. The final one, APP11, is about the security that you must have for personal information. So let's look at them one by one. Number 1, the open and transparent management of personal information. Well, that means you must have a clearly expressed and up-to-date privacy policy. You can't just say, oh, we're not going to have one, don't worry about it, we don't do anything interesting. You have to have one. And it's got to be up to date. It's got to be freely available, and it's got to be easy to understand. I wouldn't mind betting that that includes that you're probably meant to have it on your website, and you probably should be able to produce it for people on paper if they ask, because not everybody's online. And that you must take reasonable steps to implement the practices and the systems that comply with the APPs, and let them make inquiries and complaints. Again, you can't just go, oh, don't worry about it, that's not really something we care about. If you're doing that much business, you have to care. Number 2, anonymity and pseudonymity. Now, anonymity means interacting with an organisation without any identifying information. So you're not giving them a username or password or a made-up name. You just can interact with them. So, you see sort of satirical videos about this, of going into a shop and them saying, well, first you've got to create a user account and we need this and that. Even online, if you can provide a service to somebody without knowing who they are, then you're meant to. That's what this says. Pseudonymity means that you can use a name that isn't actually your legal name. So that unless there's a good reason, you can tell them a made-up name. So it says that they must give people the option whenever it is lawful and practicable to do so, including when they're making inquiries or complaints. So you should be able to make an inquiry, have you got this record in stock, without having to give them personal information. Access services, again, I should be able to go in and pay for something and access a service, provide feedback or participate in surveys and research, either anonymously or with a pseudonym. I was going to try and say that word, but I wouldn't have got there. Now, they're not required to do this when they're required by Australian law. So, for instance, if you're getting a driver's licence, they're required to confirm who you are. Likewise with a passport, when you're getting a mobile phone, when you've got a bank account, there's all sorts of things where we say, listen, there's a legitimate interest, government interest, in knowing exactly who you are, and it's often to do with law enforcement and safety. Or it's impracticable for the government or for the organisation to deal with somebody who hasn't identified themselves. So, for instance, if I wanted an email account, but I wouldn't tell you who I am, no, I'm not going to tell you my username or password, but I do want an email account. Well, if you can't tell me who you are, then how am I meant to hand you your emails? There are times, and I do this on 42 Penguins, I want to know who you are when I'm playing a game. I want to know who's on the scoreboard. So even if it's a pseudonym, I want to know something about who you are. So you've got to have a login to use it. But other things, like you can play Penguin Man without being logged in. There's all sorts of things you can do anonymously. Now, whether I'd have to comply with the law, I suspect I wouldn't. At least not this law. But it's still good practice. Number 3. The collection of solicited personal information. Solicited means you ask for it. So, it's on the application form. It's when you set up an account. It's something that you're actually saying, hey, give us this information, even if you're just suggesting it. So, deliberate collection methods. It occurs when the entity requests, invites, encourages people to provide details. You're only allowed to collect information that is reasonably necessary for the organisation's functions or activities. So, for example, on 42 Penguins, I ask you to give me an email address so that I can log you in, and I ask you to provide me with a name, but I don't verify that the name is true. So I'm just collecting what is reasonably necessary for it to function. You've got to make sure they're lawful and fair, and I suspect that that would be quite complicated depending on what you wanted to say. But again, I think for most reasonable people that would be fine. And then you're not using intrusive or unreasonably invasive collection practices. Number 6, the use or disclosure of personal information. When can they share your information? Lots of people think that, actually lots of people have no idea what privacy they're entitled to. So, first and foremost, an organisation can only use your data for the primary purpose that it's collected. So if I'm getting your email address so that you can log into 42 Penguins, then that's all I can really use it for. So the exceptions to that, if you've consented to secondary use or disclosure, if you'd reasonably expect the secondary use or disclosure. So let's say that you've signed up to 42 Penguins and you're using it to harass somebody else. Well, you would reasonably expect that I would share your email address with the school for the purposes of dealing with the fact that that account's being used to harass someone. The use or disclosure is required or authorised by law. A general situation of permitted use exists, such as serious threat to life, health or safety, law enforcement, and it says research purposes. I suspect for most research purposes you probably actually need permission. This is, I had a situation in the last 12 months where an organisation that I'd signed up for a trial with, they'd approached us and signed up for the trial, and then we discovered that they'd given our information for research, and the research was people wanting us to do surveys to say why we didn't want to do a paid version of their product. So it was in fact marketing. And we pushed back, and they hilariously claimed, oh, we're not governed by the APPs. And they are, but people will try things. So you'd be surprised. It's good to know what your rights and obligations are. Number 8, cross-border disclosure. I apologise for this image. It's all very cloak and dagger, isn't it? So this protects individuals by ensuring your personal information is secure even when it's transferred across international borders. The short version of it is that if I store your information overseas, I need to let you know that I'm doing it, and it needs to have the same level of protection as if it had never left Australia. And the kicker is, if it's mishandled, then it's actually on me. I'm the one who's in breach, and I'm the one who can get fined. So you can't just wash your hands of it and say, oh, I put my trust in the wrong people. The onus is on you to make sure that the people have legal protections in place. Number 9 is about government, the use, disclosure or adoption of government-related identifiers. Now, I was actually really surprised by how many government-related identifiers there are in Australia. It prevents you from using from them, so you can't just say, oh, I'm just going to make everybody use their tax file number, because that's really easy. It'll never be the same two people. It can be a unique identifier. That's convenient for me as a developer. Well, sure, it's convenient for you, but the point of this rule is that it's protecting the privacy and reducing the risk of somebody then running away with a whole lot of tax file numbers because I decided that it would be convenient for me to have them. So, things such as Medicare numbers. Now, this doesn't mean nobody can have it, and obviously the government uses it, but I can't just say, oh, I'm just going to use these existing things as my index, for want of a better word. Tax file numbers, driver's license numbers, passport numbers, customer reference numbers for Centrelink, and ABNs. So as you can see, there's quite a few government-related identifiers, and I can see why some developers would be tempted to say, oh, let's just use those. But you actually can't. You've got there's rules around that. I'm not going to expound what they all are here, but there are rules. Final one, APP 11, security of personal information. Entities holding personal information must implement security measures based on the sensitivity of the information. Is it medical records? Is it your passport number? Is it your driver's license? Is it your bank account details? What sort and how much information is being stored, and the possible consequences. And, places are getting hacked all the time. You are legally obligated to have appropriate protection in place. All right, we have 8 true or false questions. How are we doing for time? We're doing okay. According to APP 1, organisations must ensure that individuals are aware where they hold personal information about them and how to access it, but they are not required to publish a privacy policy. No, not even slightly true. If you're governed by the APPs, you've got to publish a privacy policy. Under APP 3, an organisation may collect solicited personal information even if the collection is unreasonable or unnecessary for one of their functions. Well, it's right there in the question, isn't it? If it's unreasonable or unnecessary, then no, you don't get to. APP 6 permits an organisation to disclose personal information to a third party for a secondary purpose without the individual's consent, provided the secondary purpose is related to the primary purpose. So yes, but you can't just wave your hands in the air and say, oh, everything's related. Oh, me wanting to sell you a product is related to the fact that I want to sell you a product. It's not as simple as that. According to APP 8, an organisation may disclose personal information to overseas recipients without taking reasonable steps to ensure the recipient does not breach any APPs. No, that's false. You can't just hand it off and just go, oh gee, I hope this works out. Under APP 9, organisations are prohibited from adopting, using or disclosing government-related identifiers such as tax file numbers for any purpose other than the purpose for which the identifier was assigned. So you can collect it. Like for instance, if you're signing up for a HEX or a help debt, then they're going to need to know your tax file number. But you can't just say, I'm just going to use that as a student ID. You actually have to have a legitimate purpose for it. Now these ones, actually I'm going to pause this for 2 seconds. Alright, let's try that again. There we go, we've seen that one. The APP requires organisations to take reasonable steps to protect personal information. Yeah, absolutely, that's true. That's all you're required to do is reasonable steps. According to APP 1, an organisation's privacy policy must be in writing and available in only one format. Well, we didn't talk about that, but I think well, not think, that's false. You've got to give people a reasonable chance to get the information. So it would have to be in commonly spoken languages. I suspect it would have to be in paper as well as electronic. And the final one is APP3, an organisation must collect personal information directly from the individual, and collection from third parties is never permitted. We actually didn't talk about that earlier, so I'd be interested to what you think the answer is. But in actual fact, no, they can get information from other people. They can do credit checks, they can do criminal checks and that sort of thing. You can get information from other places. But while we're at it, I did want to talk about APP3 because that last question deals with it. And when I wrote that, I thought, I'm going to go back and have a check at that. So when you're collecting it, you can get stuff that is reasonably necessary. You need to ensure that it's lawful and fair and that you're not intrusive or unreasonably invasive. So again, if you're buying a Snickers bar, they've probably got no business knowing what your complete financial history is or your criminal record. But if you're being employed as a teacher, then they probably want to know about your criminal record. So these things are going to vary on a case-by-case basis. So that's the end, and I hope you learned something useful from that.